AOMA, the Honorable Eduard Duamana, the Ombudsman of Ethiopia, the Honorable Dr. Ndale Hele, the Deputy Ombudsman of Angola, Dr. Aguinaldo da Costa Cristavo, Excellencies and Honorable Ombudsmen who are able to join us, distinguished participants and guests, members of the media, and senior colleagues, very warm greetings. I welcome you on behalf of the Acting Deputy Vice Chancellor and the Head of the College of Law and Management Studies, Professor Brian MacArthur, who unfortunately could not be with us due to ill health this morning. However, it is my absolute pleasure to welcome you to join this AORC webinar session themed Document Storing and Archiving. Now, this is another important topic to deliberate upon as ombudsmen and their staff handle sensitive data, which must be managed in accordance with the confines of legislation in our various jurisdictions. Now, according to the United Nations Conference on Trade and Development, the level of adoption of legislation related to access to information or the protection of personal information is at 61% in Africa. Now, the majority of African states have passed relevant laws. Now, this is reassuring as it enables the Office of the Ombudsman to work efficiently. Now, in keeping with the mandate of the AORC to promote capacity development, knowledge generation, and professionalism within African Ombudsman institutions, delegates this morning can look forward to hearing other esteemed panel members from the African continent share their insights on the issues associated with document storing and archiving. Now, the panel this morning will cover important areas such as internal, legal, and regulatory requirements, the protection and processing of personal data, how long information should be kept, and how to dispose of such information when it is no longer required. Now, I'm sure this will enable AOMA members to enhance their document storing and archiving systems, especially colleagues from states who are still at the draft stages of their legislation. Now, unfortunately, although I'm unable to participate until the end of this webinar session, I'm very confident that the insights from the panel will empower the officers of the Ombudsman in the furtherance of good governance, the rule of law, and the protection of human rights in Africa. I once again welcome you to the July webinar session of the AORC in 2022, and it is my pleasure to hand over to Advocate Thaleka, who will now formally welcome you as the acting chairperson of the AORC. Advocate Thaleka.
Thank you. The facilitator, Basanius Diakuga, the Ombudsman of Namibia, the Honorable Eduard Duamana, Ombudsman of Burundi and Treasurer of AOMA, Honorable Dr. Ndale Hele, Ombudsman of Ethiopia, the Honorable Antonia Flabella Araja, Ombudsman of Angola, the acting president for AOMA, academic leader for teaching and learning at UKZN School of Law, Dr. Freddy Ngonyani, distinguished guests, colleagues on the platform, most importantly, the AORC staff who put this together. A very good morning to you all. It is an honor to deliver this opening address this morning alongside UKZN, our formidable partners and fellow board members. I wish to thank you all for always honoring these invites. We meet yet again to draw from our one another's experience with a view to bettering ourselves so that we remain equal to the task of extending justice to the masses of our fellow countrymen and women while ensuring accountability of our governments within our respective jurisdiction. This is the latest in a series of more than 20 webinars that have taken place since the worldwide outbreak of COVID-19 in early 2020. These sessions seek to breathe life into the eye and the sea in the African Ombudsman Research Center's, which is AORC's RICA strategy. As we are all aware, this acronym stands for Research, Information Sharing, Capacity Building, and Advocacy. As mediators and ombudsman institutions, our primary work is to resolve disputes between citizens and or our residents in governments, which are organs of states, through a fair and just process that involves listening to both sides, obtaining evidence, evaluating it, and making factual findings. Where warranted, we proceed to take or recommend remedial actions through which we seek to take the complainant as close as possible to which they were, would they have not had been for the maladministration on the part of the organ of state. Accordingly, in the course of exercising our powers and performing our function, a lot of records documenting the exchange of information, correspondences, and knowledge passes through our hands. For instance, most, if not all of us, prefer that complaints be lodged in writing in a form of a small statement. The respondents in our investigation share their version of events in written form. Both the complainants and respondents can submit supporting documents to substantiate their sides of the story. We may even obtain further information and evidence independent. All that information can simply be referred to as a record. However, one is informed and therefore moves from the premise that this webinar's focus is on document storing and archiving in broad terms and not just in reference to investigations or the resolution of disputes. In other words, today we will share ideas on how our respective institution can best manage and archive records in general, transcending that which is ordinarily found in an investigation or case file. But most importantly, our institutional memory as institutions supporting democracy is in the form of records and needs to be archived and stored in a manner that generations to come after us know the work that has passed through our hands and the jurisprudence of these important institutions within the respective countries and the globe at large. As such, the invite we all received ahead of this session indicates that the webinar will zero in on internal legal regulatory requirements, protection and processing of personal data, and how long information should be kept, and how to dispose of the information when it is no longer required. For these reasons, in preparation for this brief address, one has had to compare notes on our counterparts elsewhere in the globe. From the little one has seen, there can only be no doubt that document storing and archiving is a non-negotiable for all institutions, public or private, that includes us in the mediators and the ombudsman community. In its record management policy, for instance, the Western Australian Ombudsman, one of our counterparts, defines records as inclusive of correspondence, electronic documents, forms, electronic messages, photographs, drawings, audiovisual materials, and so forth. Again, according to our Welsh colleagues, records are necessary to create confidence in any decision-making process, to promote accountability and transparency, and to enable others to verify what has been done. They add that good record keeping is vital for the corporate memory. In addition, says Public Service Ombudsman for Wales, Mr. Nick Benet, good records management also assists public authorities such as us in fully complying with their obligations under information rights legislation. In January 2022, Mr. Benet's office compiled a guide on the importance of keeping good quality records and how a failure to do so may lead to maladministration or service failure on the part of a public body. The guide further aims to demonstrate why a culture of good record keeping is vital for a responsive public sector. According to the guide, good records management means complying with legal, regulatory, business, and accountability requirements, creating a written record of decisions and key matters discussed in meetings, conversations, emails, and other communication formats, documenting the reasons for decisions, saving records in a structured or managed way so that they can be easily retrieved, and following any relevant policies and procedures. The guide also provides that good record management can achieve through following a number of key principles, which include knowing what records are held, where and who is responsible for them, having effective records management systems in place, keeping records accurate and up to date, ensuring all staff know what is expected of them, and storing records securely so they can be readily accessible when needed. Most countries have pieces of legislation that govern and regulate record keeping. For instance, I shall share with you in respect of our own in South Africa, in respect of keeping records. And furthermore to that, where Parliament has actually passed in 2013, the Protection of Personal Information Act, which aims to promote the protection of personal information processed by public and private bodies. Now, this is to illustrate to you that over and above us keeping these records, having them accessible, but there are limitations to that. The Act introduces certain conditions for the lawful processing of personal information so as to establish minimum requirements for the processing of such information. It also establishes the information regulator, which is an independent body empowered to monitor and enforce compliance by public and private bodies with the provision of what we call POPIA and other relevant laws for the Promotion of Access of Information Act of 2000. I'm certain that all of you colleagues have similar statutes in your respective countries to regulate the preservation of national records, protection of information and access thereof, ideally flowing from such crucial pieces of legislation. Every public body such as us should develop internal policies to give effect to these laws and to guide staff on how to go about ensuring compliance of these laws. It would be interesting to see how many of us in this webinar have internal policies that give effect to the provisions of such laws as our counterparts elsewhere in the world seem to have. Above all else, I am keen to drink from the cups of knowledge in relation to this subject matter. I am eager to learn from your lived experiences. As I conclude, I want to touch briefly on an important aspect that has also affected us as the public protector in South Africa regarding the provision of a record, which we named the Rule 53 in court proceedings when we are taken on review. Courts have reviewed our decisions mainly and on the inaccuracies or the inadequacy of our Rule 53 record, which seems to prove the process and procedure that we would have undertaken as the public protector when conducting our investigations. Again, as members of the global village, I have no doubt in mind that some of you have a similar system and probably have been affected in a similar way. No matter how you look at it, document storing and archiving is a critical aspect of our work as public bodies, an aspect we should take as serious as we do the core functions of resolving disputes. This is also important for the purpose of operating within the parameters of the law. You will concur, dear colleagues, that as institutions whose duty is to hold others to account for flaunting the laws. We cannot afford to be found wanting when it comes to compliance with the law as it is in respect of our own, to strip us of the credibility that is the oxygen of our existence. I look forward to hearing from our panel of experts today, just as I await with delight the discussion that will follow the presentations. I thank you all.
Thank you, Advocate Peleka. We are having a bit of a problem with the facilitator, Honorable Diakuga from Namibia. He's battling to unmute himself, so I will introduce each speaker, but I will not sum up as I'm busy with a whole lot of other technical duties behind the scenes. So after each speaker has spoken, each speaker's got 15 minutes to present. After each speaker has spoken, I will just introduce the next speaker and then ask the questions at the end, all the questions that have been raised at the end. Just ask each speaker to address each question. I'm hoping that Honorable Diakuga will be able to sort himself out during the course of the webinar. But if he doesn't, then I'll just continue introducing each person. Thank you. And I do apologize for my camera. It seems to be on the blink this morning. I'll start now with the introduction of Honorable Eduard Duamana, who is the second Ombudsman of the Republic of Burundi. He is a career magistrate who has occupied various positions as prosecutor of the Republic and later governor of the province in 2008. He invested in the mobilization of the population for development of his province. He was Home Affairs Minister from 2009 to 2015 and was decorated by the President of the Republic in 2014 in recognition of the administrative performance and legal reform he initiated. He was elected member of Burundian Parliament in 2015 and later elected second deputy president to the office of the National Assembly before being elected Ombudsman of the Republic on the 22nd of November 2016, when he was sworn in before the Burundi head of state and the two chambers of the Burundian Parliament. Honorable Duamana is the current treasurer of AOMA and a board member of AORC. Honorable Duamana, you may continue. Thank you.
Oui, merci beaucoup. C'est aussi un plaisir pour moi. Je crois que vous m'entendez.
Parfaitement, oui.
Oui, merci beaucoup. Donc, je disais que c'est aussi un plaisir pour moi d'être associé à ce travail de ce matin. Je salue d'abord la présence de tous les honorables ombudsman, chers collègues panélistes. Il m'a été demandé de développer sur le sous-thème en rapport avec les exigences internes, légales et réglementaires dans le thème général en rapport avec les archives et le classement. Je vais commencer par demander une indulgence parce que il m'a été demandé de faire ce travail un peu tardivement. Je ne sais pas si j'ai bien compris le thème de ce jour, n'ayant pas vu le lien avec le travail de nos institutions, mais après les mots d'ouverture que je viens d'entendre, j'ai bien compris que les archives et les missions de l'institution des ombudsman ont un lien très important. Je vais donc développer mon... Alors, mon exposé sera articulé autour de 4 petites parties. D'abord, je vais faire une introduction. Après l'introduction, je vais parler des généralités sur les archives. Et après, je vais essayer de montrer l'importance des archives en insistant sur le lien entre les archives et les missions de nos institutions. Et après, je vais faire une petite conclusion. En guise d'introduction, je vais d'abord... Vous le savez, Excellences, Mesdames et Messieurs, que nous sommes quotidiennement et professionnellement confrontés au règlement des conflits liés au non-respect des droits, à la violation des libertés et au mépris du droit commis par les agents publics. Je disais que nous sommes confrontés chaque fois au règlement des conflits qui sont liés au non-respect des droits, à la violation des libertés et au mépris du droit commis par les agents publics au préjudice du citoyen. Or, comme vous le savez, notre société est régulée par le droit qui réglemente et organise tous les actes de la vie nationale. Et les archives ne peuvent pas échapper à cet environnement juridique, car les règles de droit, vous le savez, s'imposent dans la gestion quotidienne de nos données et aussi de nos dossiers. Et en effet, les archives appartiennent à tous et constituent le témoin de l'histoire, le témoin d'une discipline, mais aussi le témoin d'une organisation ou d'une institution. Et les archives, comme vous le savez, apportent le témoignage du passé et du coup s'avère être une source d'information qui est, à mon avis, irremplaçable. Et pour un pays ou une organisation, les archives apparaissent aussi comme un des facteurs de bonne gestion et aussi constituent une assurance pour la continuité administrative. Les archives et leur classement sont des notions connues et auxquelles les rois tenaient il y a fort longtemps. Reconnaissant leur importance dans la gouvernance et la reconstruction de l'histoire, je vais ici vous faire un exemple par rapport aux mêmes saintes écritures. Comme vous le savez, la Bible a été écrite il y a plus de 2000 ans, mais à cette époque de l'écriture de la Bible, il n'y avait ni imprimerie, il n'y avait ni ordinateur, ni quoi que ce soit. Mais pourtant, si on fait une lecture de la Bible, mais aussi des autres saintes écritures, vous constaterez que les notions d'archives et de classement de ces archives remontent depuis longtemps. Et je vais ici faire une petite citation par rapport au verset de la Bible, par exemple. Et vous allez dans Esdras 4, verset 15, où il est écrit qu'on fasse des recherches dans le livre des mémoires de tes pères, et tu trouveras et verras dans le livre des mémoires que cette ville est une ville rebelle, funeste au roi et aux provinces, et qu'on s'est livré à la révolte dès les temps anciens. C'est pourquoi cette ville a été détruite. Vous comprenez que cet verset fait mention plus ou moins aux archives. Et quant à Néhémie, verset 7.64, il dit ceci: ils cherchèrent leur titre généalogique, mais ils ne les trouvèrent point, et on les exclut du sacerdoce. Une forme, enfin, d'une sanction liée au manque d'archivage. Et malgré que les archives et leur classement sont des notions qui datent depuis longtemps, la plupart des pays, et surtout en Afrique, les archives ne reçoivent pas d'attention proportionnelle à leur valeur et à leur importance. Et pourtant, comme je le disais, nul n'ignore que l'accessibilité aux informations publiques garantit la transparence dans le comportement des autorités publiques. Et je peux dire dans la fin de mon introduction qu'à l'absence des archives, cette garantie serait obsolète et les missions de l'Ombudsman en subiraient les conséquences. Et la deuxième partie, je vais ici aller rapidement sur les généralités en rapport avec les archives, en commençant par une définition. La définition des archives, étymologiquement, AOMA-AORC vient du latin archivum, qui signifie armoire pour les actes, et qui lui-même vient du grec ancien, signifiant un bâtiment administratif, magistrature. Et selon cette définition, qui est vraiment la plus originelle du terme, les archives représentent le lieu où l'on conserve ces documents. Donc, un bâtiment ou un local de conservation, ou encore l'institution en charge de leur conservation ou de leur gestion. Selon une autre conception, les archives se définissent comme un ensemble de documents, quelle que soit leur date, leur forme et leur support matériel, produits ou reçus par toute personne physique ou morale et par tout service ou organisme dans l'exercice de leurs activités, organisés en conséquence de cette activité et conservés à des fins administratives, culturelles ou historiques. Les archives sont donc des documents conservés pour pouvoir prouver des droits ou témoigner de certaines activités d'une part et permettre aux chercheurs de connaître l'histoire et la culture d'une personne ou l'organisation et le fonctionnement d'une institution. C'est en réalité cette définition qui me paraît la plus réaliste et qui va inspirer le contenu de mon cours exposé. Quant au droit des archives, le droit des archives est l'ensemble de règles juridiques relatives aux archives. Et il varie selon les pays, les institutions et les époques. Ce droit est constitué d'une part de dispositions concernant les archives courantes et intermédiaires et relevant pour la plupart du droit civil et du droit pénal, c'est-à-dire la durée légale de conservation, les peines en cas de vol ou de destruction, etc. Et d'autre part, il est constitué de textes spécifiques organisant la conservation et la communication des archives définitives par les services d'archives publiques. Et les archives sont classées généralement suivant leur catégorie. Et je vais vous passer de toutes ces catégories, mais nous pouvons retenir que cette classification est faite suivant l'âge ou l'origine de ces archives. Et nous pouvons noter en passant qu'il y a des archives de consultation courante qu'on appelle généralement des archives vivantes. Il y a des archives qu'on appelle dites des fois semi-vivantes et des archives historiques ou qualifiées comme définitives. L'importance des archives dans le pays, c'est ma troisième partie. Les archives, le terme archive, mémoire, histoire, c'est un trio de mots qui, selon Madame Isabelle, c'est une écrivaine que j'ai pu consulter. Cette écrivaine, Isabelle, disait que archives, mémoire, histoire, que ce sont des notions qui sont indissociables. Et c'est cette indissociabilité justement qui confirme aussi l'importance des archives et leur classement dans un pays. Les archives constituent des témoins vivants, des faits historiques qui retracent la manière de gestion et l'administration d'un pays par l'idée. Quant à Michel de Certeau, lui, il dit qu'il en va de l'histoire comme des autres sciences. Là, il veut dire les archives. Le laboratoire, ce sont ici les archives, les musées, et donc pour montrer l'importance des archives par rapport aux autres sciences. Et au regard de ce qui précède, il y a lieu de nous convenir qu'à l'époque actuelle, aucun développement n'est possible sans l'information et aucune information sans document. Ainsi donc, à partir de cette conviction, nous pouvons dégager quelques aspects de l'importance et de l'utilité des archives. Je vais relever quelques-uns. Les archives sont un des nerfs de l'administration car réunissent la totalité des informations produites ou collectées par l'administration. Elles constituent la mémoire collective de l'État et de ses institutions. Les archives aident aussi à la planification des actions de l'administration dans tous les domaines. Et les archives établissent les preuves des droits et obligations des personnes, des organisations, mais aussi de l'État. Les archives aussi suppléent à la défaillance de la mémoire humaine et la disparition des fonctionnaires qui ont constitué au développement de l'organisation, etc. Et malgré le caractère incontestable de l'importance des archives, les pays africains n'ont pas mesuré, comme je l'ai dit, on ne mesure pas à cette portée et attache moins d'intérêt à cette matière, alors qu'elle peut constituer un catalyseur au développement, à la promotion de la transparence, à aider à la bonne gestion de la chose publique. Et maintenant, je vais essayer de montrer l'intérêt des archives au service de nos institutions, et je crois que c'est ce qui nous intéresse. Et pour montrer cet intérêt, j'ai essayé de faire une comparaison de l'évolution législative sur cette matière qui nous préoccupe aujourd'hui, en comparant la législation de certains pays. Et j'ai constaté que l'évolution législative sur les archives en Afrique varie d'un pays à l'autre et dépend de l'importance qu'attache chaque pays à son histoire et à la compréhension des décideurs du rôle que peuvent jouer les archives dans le développement d'un pays. Par exemple, au Burundi, le cadre juridique des archives remonte de 1979. La loi du 9 mai 2014 a créé l'Office rwandais des archives et services et a également organisé ses missions, son organisation et son fonctionnement. Au Sénégal, qui est un pays de l'Afrique de l'Ouest, est connu pour la richesse de son histoire précoloniale et coloniale, les archives sont régies par une loi du 30 juin 2006 relative aux archives et aux documents administratifs. Pour mémoire, vous retiendrez que les archives de Dakar sont inscrites dans le registre des mémoires du monde depuis 2000 et ont été classées patrimoine mondial documentaire par l'UNESCO. Dans un autre pays comme Djibouti, un pays de la Corne de l'Afrique, qui a été indépendant depuis 1977, il n'y a pas longtemps, il a depuis organisé la gestion de ses archives et la loi numéro 132/11.6 portant sur les archives peut être considérée comme l'une des plus avancées sur le continent africain. Sommairement analysée, les législations des 4 pays prises pour montrer le lien entre les archives et le travail de l'Ombudsman nous permet de dégager ce qui suit. Le rôle des archives est très important dans l'accomplissement des missions de l'Ombudsman. Il suffit par exemple de lire quelques motivations qui ont poussé le législateur sénégalais à adopter la loi précitée, qui remplaçait celle de 1981, et analyser le rôle des archives selon la loi djiboutienne. Parmi les motivations évoquées par le législateur sénégalais, il figure au point B, et je cite, « les exigences de la nouvelle citoyenneté qui obligent l'administration d'être dans son action quotidienne à la fois transparente et respectueuse de la vie privée des citoyens. » Vous comprenez que cette motivation a un lien et concourt aux bonnes missions de nos institutions. Au point C, le souci des chercheurs d'en savoir toujours davantage et veulent accéder presque sans délai aux sources d'information et considèrent qu'il s'agit d'un droit à l'information. À elles seules, ces 2 motivations montrent qu'une bonne réglementation des archives concourt à une bonne réalisation des missions de l'Ombudsman, surtout en rapport avec le rappel que nous faisons chaque fois au gouvernement de respecter le droit des citoyens, de favoriser l'accès aux services et d'être transparent. Définissant le rôle des archives, la loi djiboutienne reconnaît qu'elles sont le garant de l'état de droit par le soutien de la prise de décision, à la bonne gouvernance, à la transparence, à l'exercice de la démocratie, à l'affirmation des droits de l'homme ainsi que par la preuve juridique qu'elle constitue. En outre, selon toujours la loi égyptienne, les archives constituent un élément essentiel de l'affirmation de l'identité nationale en même temps qu'elle témoigne des différentes périodes de l'histoire nationale. Vous constaterez, Excellences, Mesdames et Messieurs, que rien que ces courts passages législatifs de quelques pays, et pour prouver que les institutions d'Ombudsman ont beaucoup d'intérêt à ce que dans nos pays, les archives soient bien organisées et pour faciliter l'accomplissement de nos missions de protecteurs et aussi d'intercesseurs des citoyens auprès du gouvernement et des autres institutions chargées des services publics. En guise de conclusion, je vais conclure en disant que les archives d'un pays ou d'une institution, comme je l'ai dit, supra, sont d'une importance capitale. Au niveau d'un pays, les archives contribuent à améliorer non seulement l'accès à l'information, la transparence et la bonne gestion de la chose publique, qui sont des éléments facilitant le travail de nos institutions, mais aussi les archives permettent la réconciliation des peuples à travers la revue de son histoire et de sa culture. C'est d'ailleurs en passant pourquoi, à mon avis, j'encourage et félicite les pays africains qui sont en train d'exiger à leurs anciens colonisateurs le retour des archives emportées lors de la colonisation. En guise de recommandation, en tant qu'ombudsman, je crois qu'il est important de recommander à nos gouvernements à ce que l'évolution des archives en Afrique tienne compte de l'émergence des nouvelles technologies, de l'information et de la communication. Nous devons également sensibiliser nos gouvernements et les partenaires au développement sur l'importance des archives. Nous devons également impliquer nos institutions à la sensibilisation de la population à la lecture de nos archives, parce qu'il s'est avéré que les populations, les peuples africains n'aiment pas à lire, et encore moins ne consultent pas à leurs archives. Nous devons également recommander à nos gouvernements la mise en place d'un système efficace d'archivage des données électroniques et numériques. Voilà ma petite contribution, Excellences, Mesdames et Messieurs, et je vous remercie pour votre aimable attention. Agréable journée.
Thank you, Honorable Duamana. Honorable Diakuga, can you speak now? I see your microphone is unmuted, so I'm not too sure whether you can speak now. Okay, it seems like Honorable Diakuga is still having a problem.
Marion, unmute yourself. We can't hear you. Marion, unmute yourself. We can't hear you. We can't hear you, Marion.
Okay, thank you. I've just unmuted myself now. It has the Honorable not able to connect, Honorable Diakuga.
Not yet. Carry on, Marion.
Okay. I'd just like, thank you, Honorable Duamana. I'd just like to repeat your conclusion. The archives of a country or institution are of paramount importance. At the country level, the archives contribute to improving not only access to information, transparency, and good governance, which facilitates the work of the Ombudsman, but also the archives allow the reconciliation of peoples through the review of their history and culture. With that, we encourage and congratulate the African countries that are demanding from their former colonizers the return of the archives taken away during colonization. Thank you, Honorable Duamana. Our next speaker is Honorable Eduard Haley, the Ombudsman of Ethiopia, who will speak about the protection and processing of personal data. Honorable Indale Haley is, please, I'm apologizing if I'm not pronouncing it correctly, Honorable Ombudsman. Honorable Haley is the current Ombudsman of Ethiopia who was appointed in July 2019. Previously, he was the Vice President for Administrative and Student Affairs in Debre Berhan University, 2018, Dean of Students from 2015 to 2018, and Assistant Professor 2010. He was also a Member of Parliament from 2005 to 2010. His short-term training includes BPR, Public Policies and Strategies, the role of legislative in law and budget-making process, project management, finance and rural development, research methodology. His membership of professional bodies and various committees are the Ethiopian Management Professional Associations, Director for Student Services Supportive Work Process, Chairperson for Purchasing Approval Committee, and Chairperson of Discipline Committee in DBU. He's an MBA lecturer in Strategic Management, Project Management and Planning, Public Project Management, Human Resources Management, Research Methodology, and Leadership and Change Management. Thank you, Honorable Haley. The floor is yours.
Thank you, Marion. Good morning, honorable ladies and gentlemen. I wanted to say all welcome to this webinar discussion on document storing and archiving. My name is Ndal Haile, and I am Chief Ombudsman. And my presentation is focused on protection and processing of personal data. This content about protection and the processing of data is important as Ombudsman and as information commissioners. And these presentations will cover some points or some issues about the historical background of personal data regarding the definitions of privacy, data processing, personal data, and the different principles of data processing and personal data, and the legal basis for protections of personal data from international and African context, and personal data in Africa and from Ethiopian experience, and what are the challenges to implement the protections of personal data. And I have some solutions or recommendations the way forward. Historically, the personal data and the different government and other human consortia have 4 years gathered important and personal information on pupils. And while much of this information was recorded in relatively primitive filing systems, and its mere existence made the concept of privacy virtually non-existent. For example, government officials of the Roman empires maintained an extensive system of taxation records on its subjects throughout its sphere of roles, and recorded by scribes on papyrus and scrolls. And basically they are using, or they are recorded these personal data of the taxpayers. Similarly, in Greek and Egyptian cities, personal information was maintained by bibliophiles or record keepers who were placed in charge of the public record offices. And over the past 25 years, the advancement of technology has contributed for the growth of protections of information due to different reasons, especially in those in Europe. And Europe have implemented extensive legislation to cover the use and the misuse of personal information by government, and in some cases by the private sectors. And the development of multimedia workstations, however, will change what is considered a traditional file system. As a result, various countries have adopted laws and policies to process and protect personal data. And most data protection legislations deals with the collections and the use of aggregate data organizing in database, filing systems, and storage media. Therefore, the data protection law to reflect technological change will become a critical factor. And in 1990s, the ushered in many dramatic advances in information technology, especially in the areas of artificial intelligence, relational database, and interactive telecommunications and distributed data processing systems. So one of the important points in relation to processing of the data and in personal data, the issue of the privacy is important to understand. So various scholars have defined privacy in different ways and approaches. Among these scholars, Zalman Khan stated that a man without privacy is a man without dignity. So privacy has historical roots in ancient Greek philosophers' discussions. And the most well-known of this was Aristotle's distinctions between the two spheres of life, the public sphere of the polis, associated with the political life, and the private sphere of oikos, associated with the domestic life. And the adjective of this is private, from which the English noun privacy derives. So privacy has been described in three ways. First, privacy in making certain significant self-defining choices. Secondly, privacy of personal information. And thirdly, privacy as it relates to an individual's personal space and body. According to the Universal Declarations of Human Rights, defines privacy in Article 12, stated that no one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, nor to attacks upon his honor and reputation. Privacy can include protecting all forms of personal communication, the personal body, which includes biometrics and the medical, personal data, personal informations, which include name and address, personal possession, and such as properties. Therefore, privacy, while considered a principle of data protection, is a fundamental right within itself and is associated with protecting a person's identity. So the second point is about the concepts of data processing. Data processing can be defined under the General Data Protection Regulations, which is the European the laws, and they are defined data processing as it is the performance of operation on personal data, and will include, among others, collection, storage, retrievals, usage, disclosure, transfer, structuring, alignment, or combinations, including indexations and erasure. So there are some legal bases for processing personal data. One of the legal bases of processing of personal data is a consent. The data subject has given permission for the organization to process their personal data for one or more processing activities, and the consent must be freely given, clearly, and easy to withdraw. So organizations need to be careful when using consent as their legal basis now. Sometimes process of data may be permitted without consent of the individuals due to for the functions of parliament or for any court of judgment or to report for medical emergencies. The second legal basis for processing personal data is performance of contract. Self-explanatory rights, and the data processing activity is necessary to enter into or perform a contract with the data subject if the processing activity does not relate to the terms of the contracts. The third legal base is legitimate interest. This is processing activity that a data subject would normally expect from an organization, and that it gives its personal data to do, like marketing activities and fraud prevention. What data should be confidential? The fourth legal basis is a vital interest. Sometimes personal data is important in the case of emergencies or in the case of medical situations. The fifth legal base is legal requirements. Legal requirement is the processing activity is necessary for illegal obligations such as an information security, employment, or consumer transactions laws. And the sixth and the final legal base for processing of personal data is public interest. Public interest is a processing activity that would occur by a government entity
It looks like we've lost the speaker, Frankie.
He's trying to reconnect.
Okay, thank you. Should we wait for a few minutes?
It's up to you, Marion. We can move to the next speaker and then we'll come back to him. Marion, we can move to the next speaker. We'll come back to Dr. Haile.
Okay, Dr. Haley has lost his connection, Dr. Haley, and we will introduce the next speaker, which is on Dr. Aguinaldo Guedes da Costa Cristóvão. He's the Deputy Ombudsman of Angola, who is presenting on behalf of Honorable Antonio Florabella de Jesus Rocha, who is the current Ombudsman of the Republic of Angola. She was elected by the National Assembly in May 2021. Currently a member of the board of the International Ombudsman Institute, holds a master's degree in international law and a law degree by the University Agostinho Neto in Luanda. She received training on human rights in Angola, Portugal, and United Kingdom of Great Britain. She has participated in several work groups on projects for the elaboration of legislation, has experience in the field of international relations, was a lecturer at the Law School of the Catholic and Louisiana Universities in Angola, and at the Faculty of Letters and Social Sciences of the Agostinho Neto University. Honorable Rocha was also Secretary for Judicial and Legal Affairs of the President of the Republic and Deputy Ombudsman of the Republic of Angola. Unfortunately, due to the short notice, we didn't get the bio of Dr. Cristóvão. He's presenting. His topic is how long information should be kept and how to dispose of the information when it is no longer required. Dr. Cristóvão, you may proceed.
Muito obrigado, muito bom dia a todos. Quero antes agradecer ao convite que foi formulado, de início à provedora de que tenho aqui a honra de representar. Nós trazemos o tema sobre o arquivo de armazenamento de documentos para Nós vamos procurar partilhar aqui um
We
PowerPoint.
are going to be sharing our experience.
Vamos partilhar aqui o nosso documento de apresentação. Nós vamos proceder a esta apresentação sobre esta temática relacionada a armazenamento de documentos e arquivos em três tópicos principais. O primeiro deles para abordar um enquadramento sobre a gestão documental e gestão de arquivos. Numa segunda parte, vamos tratar das questões relacionadas ao próprio processo de arquivo em geral e como ele se pode aplicar às instituições do provedor de justiça. E temos um último tópico de desafios e perspectivas antes de passarmos às considerações finais. Assim sendo, nós gostaríamos de primeiro apresentar uma reflexão sobre esta temática, dizendo que o tema da gestão de documentos e de arquivos hoje é fundamental. Portanto, hoje nos nossos dias, nas nossas dinâmicas ao nível das instituições do provedor de justiça, nós trabalhamos com a informação que é proveniente dos cidadãos. Também temos assistido a um processo de renovação de equipas de provedores de justiça, ao mesmo tempo que nós recebemos no dia a dia informações, arquivos das diversas entidades visadas, das entidades públicas sobre os cidadãos. E é necessário que o provedor de justiça e os seus serviços possam ter condições para gerir esta informação. Este é que é o cerne da nossa temática sobre gestão de arquivos e gestão documental. Quero deixar uma nota final para agradecer
Sorry, Excellency, sorry, Honorable. Sorry, I might have to stop you a bit. We don't have the interpretation, the Arabic to English. Viriato, are you there? Sorry, I'm checking with our interpreter. Viriato, are you there? Sorry, just give me a second. I'm checking with the interpreter. We've lost our English to Portuguese interpreter. Oh, he's back in. Viriato, are you in? Okay, perfect. You can carry on now, Honorable. Sorry about that. Yeah.
Muito obrigado. Dizia que nós queremos agradecer à AOMA por esta temática para a discussão, porque isto tem uma relação direta com o nosso dia a dia, com a nossa atividade administrativa ao nível dos serviços do provedor de justiça. Duas questões conceptuais, entrando para o primeiro tópico sobre o enquadramento da gestão de documentos. Haverá a necessidade de distinguir dois conceitos chaves que aqui são apresentados. O primeiro deles é o de documento e o segundo de arquivos. Nós consideramos o documento como um suporte em relação constituído por informações e que é habitualmente utilizado para fins de consulta ou como fins de prova. Portanto, o documento é todo e qualquer suporte em relação ao qual recai informação. O arquivo, nós temos uma perspectiva objetiva e subjetiva, ou seja, nós podemos abordar o arquivo enquanto a instituição, portanto, de guarda de documentos, que também se designa como arquivo, como o conjunto de documentos de diferente natureza que nós habitualmente utilizamos para acolher a documentação produzida pelas mais variadas entidades. No caso, hoje nós temos uma abordagem sobre a gestão de documentos, e esta matéria que aqui nos congrega, nas abordagens mais recentes, integram, quer seja a abordagem tradicional da gestão documental, esta que é a que nós conhecemos, a tradicional dos documentos em suporte físico, como uma abordagem mais moderna, que integra já as novas tecnologias de informação e comunicação. Hoje, tanto a nível das nossas instituições como a nível das mais variadas entidades, já se começa a evoluir para uma discussão sobre a inteligência artificial no processo de gestão de arquivos e de documentos, como também nós vamos aqui referir. E um dos objetivos principais aqui de todo este esforço e de reflexão sobre a gestão documental é procurar uma automação de alguns processos de modo a tornar mais célere o nosso trabalho ao nível das instituições do provedor de justiça. Bom, quando nós falamos da gestão de documentos como tal, nós precisamos de distinguir o seu processo. E este processo tem 3 fases principais. A primeira delas é aquela em que nós produzimos a documentação, portanto, quando nós produzimos uma resposta ao cidadão, quando é produzida qualquer comunicação a uma entidade visada, nós estamos na primeira fase, se quisermos, da gestão documental. Temos uma segunda fase, que é a utilização, ou seja, a partir do momento em que essa informação recai sobre um determinado suporte, é apto de espoleta um processo administrativo que vai incidir sobre a recepção a emissão do documento, a recepção do documento, a sua consulta, o seu registro e também o seu armazenamento. E é nesta fase da utilização dos documentos que nós gostaríamos de colocar ênfase num aspecto que consideramos importante, que é a classificação dos documentos, que é uma matéria que vamos dedicar alguns minutos aqui. A última fase da gestão documental é a destinação, aquilo que nós também poderemos chamar como destino final dos arquivos. E esses arquivos tanto podem, após a sua utilização, ser ou arquivados ou mantidos para algum trabalho corrente, ou então poderemos dar um outro tratamento, como, por exemplo, a digitalização. O que eu quero dizer é que nós temos hoje, para este webinar, uma capa de processo que eventualmente nós tenhamos, que a vamos utilizar durante algum tempo. Mas daqui a 2, 3 meses esta capa vai ter de ir para um outro local que não há de ficar nas nossas mesas. E, portanto, é aqui que nós estamos a falar das questões ligadas ao destino, essa última fase, que, em regra, dá lugar àquilo que também nós chamamos de arquivamento, e que vamos ver que, na verdade, tem uma outra designação e, do ponto de vista técnico, tem um outro entendimento. A questão inicial e para as provedorias de justiça, um dos desafios é como tornar expedito o nosso sistema de registro de correspondência. E, portanto, ao longo dos anos, têm sido ensaiadas várias soluções de registro de correspondência, mas temos verificado e cada vez mais a tendência é começarmos a informatizar os sistemas de registro de correspondências, pelas razões que referi, portanto, celeridade. E, mais do que isso, poder garantir um processo de melhor gestão documental, melhor organização da documentação e, portanto, uma melhor estruturação da informação que nós temos ao nível das nossas instituições. Como é que nós podemos entender e qual é a importância que nós devemos dar a esta temática que hoje nos congrega, da gestão documental e da gestão de arquivos? Qualquer semelhança com as imagens que nós estamos aqui a apresentar a título ilustrativo é mera coincidência. Portanto, nós, ao percorrermos as nossas instituições, vamos ver alguns gabinetes, algumas mesas com documentação organizada, com documentação empilhada. Quando esta documentação estiver empilhada, por mais que haja um fluxo de documentação, isto significa que aí existem problemas de gestão documental. E para o provedor de justiça que recebe informação de várias fontes todos os dias, portanto, este é um aspecto crítico da sua atividade, quer dizer que exatamente a solução para a parte da sua eficiência está numa adequada gestão documental e arquivística, precisamente para garantir, evitar a burocracia e garantir, digamos, a sua própria eficiência. Permitam-me fazer um apontamento legal em relação a esta matéria e aqui fazendo um recorte da Constituição da República de Angola para compreender nesta abordagem sobre gestão documental e armazenamento, quer dizer, documentos como de arquivos, o que é que está em causa? Como nós referimos aqui, o que está em causa, na verdade, é informação. Mas este webinar é de provedor de justiça. E a questão é, qual é a relação de uma coisa e outra? A relação está exatamente ligada no acesso ou não de informações. E este acesso pode ser interno ou externo, ou seja, a partir dos próprios funcionários e agentes administrativos das provedorias de justiça, como a partir do cidadão. E este é o princípio do habeas data que existe em quase todos os ordenamentos jurídicos, precisamente corresponde à regra da nossa atividade. E a gestão documental, ela é também importante por causa disso, porque no dia a dia nós precisamos de ter os documentos disponíveis para a consulta dos cidadãos, para as outras áreas poderem trabalhar sobre elas, e também os próprios órgãos da administração pública regem-se por este mesmo princípio. De modo que também a Constituição da República de Angola consagra este princípio do habeas data, que permite então que os cidadãos possam ter acesso à documentação. O que significa que os provedores de justiça também devem garantir, força desta posição constitucional, que os seus documentos estejam disponíveis e essa disponibilidade deve ser organizada. O habeas data, como dissemos, é o princípio. E este princípio geral do habeas data, como aqui referi, e no nosso ordenamento jurídico, tem essencialmente dois eixos. Portanto, um deles está muito relacionado com o facto de que, por vezes, na nossa atividade, nós precisamos de partilhar alguma documentação com os cidadãos e, às vezes, até com as entidades visadas. E, portanto, este é um princípio que também, no nosso ordenamento jurídico, em Angola, digo, é suportado por dois regimes jurídicos essenciais. O primeiro sobre a lei de acesso de documentos administrativos, o segundo sobre as normas do procedimento e da atividade administrativa. Como disse, o habeas data é a regra, mas existem exceções. A nossa experiência no dia a dia é que nós partilhamos com cidadãos e com instituições públicas informações no âmbito dos requerimentos dos cidadãos. Mas, na verdade, por força e no âmbito de uma gestão documental correta e também por força da própria lei, nem tudo pode ser partilhado. Existe aquilo que são os limites de direito ao acesso dos documentos. E três matérias devem presidir a esta exceção. Primeiro deles, questões ligadas à confidencialidade. Segundo, questões de natureza procedimento técnico. Portanto, rapidamente, a confidencialidade tem a ver com a classificação dos documentos e a existência de dados pessoais. por vezes, que existem nos documentos e que não convém partilhar com terceiros, sob pena de violação de direitos de personalidade. Quando falamos aqui das necessidades de processamento técnico, nós estamos a falar naqueles casos em que, em relação à documentação existente, haverá necessidade de instruir de modo adequado. Depois falamos de razões de natureza organizativa. Este é um princípio que se aplica principalmente às instituições que já trabalham, ou seja, a nível das entidades públicas que têm necessidades de primeiro organizar a documentação antes de a disponibilizar. E depois temos as questões relacionadas com o segredo de Estado, que também pode ser uma restrição para o próprio limite ao acesso de documentos para os cidadãos. Portanto, o que é um tópico específico do que estivemos aqui a referir e que também interessa à atividade do provedor de justiça? É o regime de sigilo profissional que impede o provedor de justiça. Este sigilo, enquanto padrão ético e legal, ele está incorporado, quer seja nas boas práticas, no regime geral de ética de provedor de justiça, funcionários e agentes administrativos. No caso de Angola, existe mesmo um artigo, o artigo 14º da Lei Orgânica do Estatuto do Provedor de Justiça, que consagra exatamente o sigilo como um dever do provedor de justiça. Portanto, nós temos uma norma específica para esta matéria. E a questão que nós colocamos, o que é que está na base da existência de uma regra exata sobre este sigilo? O que nós pensamos é que, porque referimos atrás, o que está aqui por detrás é a necessidade de proteger outros direitos. Só assim é que podemos também entender que, em alguns casos, o provedor de justiça não deva disponibilizar toda a informação que às vezes tenha a seu dispor. E, portanto, como corolário do que referimos atrás, diríamos então que existe aqui nesta matéria ligada ao sigilo 3 aspectos mais concretos, nomeadamente a questão da proteção da individualidade, da inviolabilidade da privacidade, a questão da vida privada que deve ser preservada, a questão da honra e também a questão da imagem das pessoas. E todas estas matérias são consideradas como sendo passíveis de constituir para o provedor de justiça um limite. Já quase a terminar, estou a ser breve, nós temos um aspecto que é fundamental para a atividade também do provedor de justiça nestes casos, e que é um regime geral, que é o regime de classificação de documentos que, como referimos, na sua tramitação, corresponde à segunda etapa da tramitação. É necessário que alguma documentação de caráter mais sensível que os provedores de justiça possam ter acesso, possa ser classificada. Portanto, a classificação é uma das formas com que a própria entidade pode restringir o acesso a terceiros. E, portanto, nós temos aqui um regime que corresponde à legislação angolana dos níveis de restrição de acesso de documentos. Permitam-nos também, num segundo tópico, fazer uma abordagem mais específica sobre a gestão arquivística como tal. O que é que nós estamos a referir? Portanto, nós passamos de uma matéria em que estivemos a falar basicamente dos documentos e vamos olhar para a gestão arquivística como enquanto processo ao nível da instituição provedor de justiça. E, portanto, aqui o que nós temos em consideração é o seguinte: por vezes, ao nível da instituição provedor de justiça, existem processos que podem ter alguns anos e, às vezes, pode haver a necessidade dele ser repristinado, ou seja, depois de alguns anos, termos de voltar a consultar, a trazer, chamar à colação este mesmo processo para efeitos de tratamento ou da mesma questão, por não ter ficado resolvida, ou por uma ligação com outra matéria. E, portanto, o provedor de justiça necessita de ter esta informação devidamente organizada. E a questão que se coloca é que esta organização dos arquivos, porque já temos vários documentos que já estão devidamente sistematizados, devem ter depois uma lógica que para o provedor de justiça deve ser específica. Habitualmente, esta organização arquivística é que dá lugar aos processos de estatística que nós temos apresentado. E, portanto, a gestão arquivística é a melhor garantia da salvaguarda da informação do provedor de justiça. Nós temos aqui alguma informação, legislação essencial, que nós vamos passar, e vamos dedicar-nos a um ou dois tópicos que consideramos importantes nesse último capítulo, que tem a ver com o âmbito da aplicação. Bom, o escopo, o âmbito da aplicação do regime geral de arquivos tem a ver com, quer seja documentos ou arquivos, de pessoas singulares ou coletivas, portanto, aqui inclui-se o provedor de justiça, que são produzidos no país, em Angola ou fora dele, e que devem ser considerados como sua propriedade ou ser restituído independentemente da sua forma. E aqui estamos também a trazer já abordagens sobre as novas tecnologias, o que significa que quando nós olhamos para esta diferenciação entre arquivos privados e arquivos públicos, nós temos o provedor de justiça enquadrado nos arquivos públicos, que significa que os provedores de justiça regem-se pela legislação pública existente sobre arquivos. E os princípios que devem reger, e um dos leitores anteriores já referiu, e eu aqui faria um recorte da legislação nacional de Angola, é de que os princípios que regem o provedor de justiça são o da proveniência, o da pertinência, o das três idades e da territorialidade. A legislação angolana, em particular, incorporou um outro princípio que é o da verdade, que é o princípio segundo o qual presume-se que a documentação que nós temos nos nossos arquivos seja real, seja verídica. E, portanto, este é um princípio que nós mais aqui à frente vamos referir. O princípio das três idades, e aqui, esta é a componente prática da gestão de arquivos. Portanto, o princípio das três idades, que é o primeiro tópico que nós temos aqui em matéria de classificação, significa o seguinte, em termos práticos. A documentação que nós temos na nossa mesa, no dia a dia, durante um determinado período, pode ser classificada como ativa, semiativa ou inativa, em função de um determinado critério que é do tempo. Em razão do ciclo vital, que era aqui o último tópico, digamos, deste slide, nós temos aqui três linhas, nomeadamente, temos os arquivos correntes, arquivos intermédios, arquivos definitivos. E aqui permitam-nos uma clarificação, porque isto tem a ver com o nosso dia a dia. Os arquivos correntes são aqueles arquivos que nós temos nas nossas pastas do processo, no dia a dia. São os que nós utilizamos. E, portanto, habitualmente, os arquivos correntes e intermédios são aqueles que nós utilizamos enquanto ainda há uma necessidade de termos uma informação, uma documentação no nosso dia a dia. Quando nós colocamos aquela documentação numa pasta de arquivo, depois de algum tempo, e já não utilizamos no dia a dia, eles passam para um outro estágio que é o de arquivo intermédio. Portanto, por vezes nós colocamos numa outra sala e, portanto, nós só vamos consultar, por exemplo, numa sala de secretariado contígua, e só vamos consultar quando temos exatamente esta necessidade. E também as instituições têm aquilo que nós chamamos de arquivos definitivos permanentes ou históricos, que em regra é uma zona em que só fica arquivada a documentação. Muitas das instituições do provedor de justiça não têm este arquivo permanente, definitivo ou histórico, porque têm Portanto, Portugal tem 50 anos de provedor de justiça, mas a nível da África, habitualmente, as instituições de provedor de justiça têm uma média de 20 anos ou menos, e, portanto, habitualmente é este o último tópico dos artigos correntes, intermédios e históricos que constitui o dia a dia da nossa atividade. Qual é o caso do provedor de justiça de Angola? Em Angola nós temos o arquivo físico e o arquivo digital. O processo de gestão arquivística está sob a responsabilidade de uma área, que é a secção de expediente e arquivo. Existe um software de gestão de arquivos. E, portanto, o que nós poderemos dizer é que temos ensaiado outras soluções visando a gestão documental. Para concluir, eu gostaria de apresentar os desafios e notas finais. Os primeiros desafios que nós temos ao nível das instituições do provedor de justiça é da implementação do mecanismo de digitalização e base de dados. Nós pensamos que este será um aspecto muito importante que deverá concorrer para a celeridade e eficiência do serviço do provedor de justiça. Fazendo uma nota aqui de que as boas práticas recomendam que o arquivo digitalizado não deve substituir o original, e este é o que dá lugar ao segundo desafio que teremos de futuro, que é a temática da destruição de documentos. É necessário dizer...
Excuse me, Honorable Ombudsman, my apologies. Can you please wrap up if you don't mind, please? Can we give you 2 more minutes just to wrap up, please?
Podemos lhe dar as perguntas para terminar?
Sim, muito obrigado.
Thank you.
Muito obrigado. Temos a questão da destruição de documentos. A regra é não destruir documentos. E temos também a questão da criação de uma comissão de avaliação a nível dos provedores de justiça, porque este não é um trabalho do provedor de justiça ou das áreas de gestão de expediente, é um trabalho de uma comissão específica. Portanto, a existência de arquivos próprios é um desafio importante. As notas finais são de agradecimento, para referir que a formação é o elemento mais importante, quer seja a nível de recursos humanos, quer seja a criação de condições técnicas para o trabalho do provedor de justiça. E, portanto, tendo uma má classificação de documentos, uma má gestão documental, basicamente nós não estaremos ainda a alcançar os princípios da eficiência, da celeridade e da acessibilidade a que estamos vinculados enquanto servidores públicos e funcionários de uma Procuradoria de Justiça. Muito obrigado e peço desculpas pelos minutos adicionais que acabei por retirar. Muito obrigado.
Obrigado, Ombudsman. Thank you very much. We will now go back. We do apologize firstly for the quality of the interpretation. It seems like the interpreters are having connectivity issues. We will arrange for the presentations to be translated and sent to all the participants. Honorable Haile, are you available to continue and finalize?
Yes, I am available. Yeah.
Thank you, Honorable. You may continue.
Okay. Okay, next slide. Sorry for internet interruption and instability. To the next slide, please. Okay, so I am stopping on the definition of personal data. Personal data can be defined, it is information or personally identifiable informations, and is any information related to an identifiable person. And for legal purpose, we can define personal data The effective definitions, it's vary from place to place and from country to country, but depending on the jurisdiction and the purpose for which the term is being used. So the term personal data is significantly its broader concept, and that determines the scope of regulatory regimes. And the National Institute of Standard and Technology defines personally identifiable informations as any information about an individual maintained by any agencies, including any information that can be used to distinguish or trace an individual's identity, such as name, social security number, date and the place of birth, mother's maiden name, and biometric records. And the second element is any other information that is linked or linkable to an individual, such as it may be medical, educational, financial, employment information. So, for example, a user's IP address is not classed as personal identification informations, but it is classified as a linked personal informations. However, in the case of European Union, the IP address of internet subscribers may be classed as a personal data. So personal data is defined under the General Data Protection Regulations as any information which is related to an identified or unidentifiable natural persons. So it's not included the legal persons. In the case of EU's directives, for the purpose of the directive, they have defined in its Article 2A, personal data shall mean any information relating to an identified or identifiable natural persons, and an identified person, one who can be identified directly or indirectly, in particular by reference to an identification number or to one or more factors specific to his physical, physiological, mental, economic, cultural, or social identities. No. In our case, or in Ethiopian case, personal information can be defined in different legal documents. One of the definitions that enacted in freedom of information, that we are accountable or responsible to implement these regulations. According to this regulation, personal information means information about an identifiable individual, including but not limited to information relating to the medical, educational, or the academic, employment, professional, or criminal history of the individual, or information relating to financial transactions in which the individual has been involved, and information relating to the ethnic, national, or social origin, age, pregnancy, marital status, color, sexual orientation, physical or mental health, or well-being, disability, religion, belief, concise, culture, language, or birth of individuals. All these issues have included as a personal information. Information relating to any identifying numbers, symbol, or other particular assigned to the individuals. It maybe includes the address, fingerprints, or blood type of the individuals. And the final element of these definitions contain about the personal opinions or views or preferences of the individuals, except where they are about another individual or about proposal for a grant, an award, or a prize to be made to another individual. Why it is important protections of personal data. Nowadays, different personal data have exposed for criminal purposes, or maybe government uses for different purposes. No, but it is important to protect the personal data through different regulations, or by establishing different authorities that have a mandate to regulate the protections of the personal data. To protect individuals' fundamental rights, as I mentioned earlier, the personal data is a part of a privacy. It is a part of a private life. No? So it is considered as an individual's fundamental rights. No? So protecting a personal data means protecting an individual's fundamental rights and its freedoms, in particular, the right to privacy with regard to data processing, and to administer all rules and procedures to be implemented during processing activities. Nowadays, the advancement of information technology and database, computer network, and mass storage techniques have exposed individuals around the world to threat of both the passive and active surveillance and controls. So data protections also been characterized as a tool of privacy. So data protections as a tool of privacy help us to facilitate the economic growth in the trade of personal data. And sometimes, or in some countries, the personal data could generate different incomes in different countries. No? So that's why it is important to protect the personal data. So there are some principles that govern or holds the personal data protections. One of the principles is preventing from harm to the government or agencies or different individuals have responsibilities to prevent the personal data, or to use or to misuse of informations for different purposes. The second principle of personal data is its notice, which ensures that individuals are able to know what information is collected about them and for what purposes. When agencies or organizations have collected individuals or the personal data, it must be notified for the personalists about the purpose, about the objective why that agencies could be collected the personal data protections. The third principle is the collection limitations. There are limitations about the personal informations. We have a private life, we have different confidentialities about personal data. So we can't have a limit or a scope which types of personal information should be given or collected by different agencies. And the other principle is about the use. For what purposes that we are collecting that information? Is that for the purpose of tax, or is that for the purpose of different national census, or for different policies and legal issues? So we can determine, or we can define the use of the personal data. The fifth principle is choices. We have a choice. The individual should be ensured that provided with a choice in relation to the collections, use, transfer, and the disclosures of their personal informations. And the other principle is integrity. Integrity is an important element of the protections of data, because it ensures the personal information, whether it be accurate, complete, or it's kept up within a date. The other principle is the issue of security. In Africa, it is challenging to keep the security, to keep the confidentiality of the personal data, but the protections of personal data also contributed to secure the personal data or the personal information. The other principle is access and corrections. If it is important, we can access the informations for different organizations or for different purposes now. And if there are corrections or updating, we can also update that information based on the situations or based on the context that we have collected that information. The other principle is about the accountability issues. Both the agency as well as individuals have an accountable for that that information or for that personal data. So in order to ensure both the organizations and the individuals to handle the personal data must be accountable. These are the main principles that we are protecting the personal data. In this regard, there are different international laws that determines or that enacts about the personal data. But different international communities understand the extent of the issues that have currently surfaced and will continue to pose challenge across the world in regard to data protection. As I mentioned earlier, the advancement of technologies can expose the personal data. So you can collect easily the personal data. So in order to protect the personal privacy, the fundamental rights of the individual, it is important to formulate different laws. But nowadays, there is no a single treaty or convention that have signed by different members of the countries about the personal data. In addition, there is no clear model laws. In different countries have a fragmented laws about the personal data. So it is important to have model laws that we govern those members of the countries or different institutions, whether it be a national or a regional institutions. This because in different countries or a personal data have a various natures. It is varies from country to country, from region to region, from across the globe. So in this case, there is no a comprehensive or a consolidated laws about the personal data. There are international organizations that have been involved in data protections, have focused on their efforts on developing concepts, principles, guidance for the countries to consider whether to include them into their national laws. So the protections of privacy under the international legal framework dates back to just after the World War II, and the enactment after the enactment of the Universal Declarations of Human Rights, which enacted in 1948. So these declarations stated that no shall be subjected to arbitrarily interference with his privacy, family, home, or correspondence, or nor attacks upon his honor and reputations. And everyone has the right to protections of the laws against such interference. So based on this general framework of the laws, different countries have enact different laws regarding the personal data. As I mentioned earlier, no international organizations that are responsible for personal data, but the United Nations or the United Nations Conference on Trade and Development is responsible for policy-oriented analytical work on the development implications of information and communication technologies. And these institutions is also responsible for the preparations of thematic reports that are related to ICT for development and promotes international dialogue on issues related to information communication technologies for development, to measure the information economy and to design and implement relevant policies and legal frameworks. So in general,
Ombudsman?
Yeah, sorry.
So sorry, may I give you 2 minutes to conclude, please?
Okay.
My apologies. Thank you.
Okay, so it's important to mention about the experience of the personal data and the protections in Africa. So Africa's in other like developing countries, we do not have a comprehensive laws, and even we do not have to protect the individual's privacy rights. But in particular, the privacy of the individual is not considered a high priority by most Asian and African governments, and most constitutions in Africa expressly guarantees the right to privacy, so including our constitutions. The formulations of these constitutions provisions closely follow Article 12 and 17 of the Universal Declarations of the Human Rights, which is enacted in 1948. However, there are privacy policies at the regional levels and in sub-regional levels. For instance, there is the EU Conventions on Cybersecurity and Personal Data, and the ECOWAS Supplementary Acts, the SADC Data Protections Model, the East African countries' legal framework for cyber laws, and those Francophone binding corporate rules have enacted about the personal data. So in general, according to the UN Conference on Trade and Development in Africa, 16% of the African countries have a legislations about the personal data protections. Only 11% have a draft legislations. Those 19% of the countries have no legislations on data protections and the privacy laws, and those 9% of the countries have no data about these data protections and privacy laws. Regarding in Ethiopia, the constitutions have enacted or grants a right to protect the private lives or the personal data in its different articles of the constitution. For instance, in Article 26 of the constitutions stated that everyone has the right to privacy, including the right not to be subjected to search of his or her home, personal or property, or the seizures of any properties under his or her personal possessions. In our proclamations, which refers to the mass media and freedom of information, contain some provisions about the protections of personal data. For instance, it's stated that any public relation officers must reject a request for access to a record of the public body if its disclosures would involve the unreasonable disclosure of personal information about a third parties, including a deceased individual who has passed away before 20 years. So, like other African countries, the laws related to personal data in Ethiopia, it is fragmented. It is contained in different regulations. For instance, the constitution has mentioned about personal data, the freedom and mass media agencies stated some issues about the personal data, civil code, criminal code, the criminal procedures, the food, medicine, and health care, the communication service, computer crime proclamations. All these laws have stated about the data protection laws. So in the same way, we have no regulatory authorities who are responsible or which organizations are mandated to regulate the personal data. This is the main problems that we face in our country as well as in different developing countries, including in Africa. For instance, Ethiopian institutions of Ombudsman has only a mandate to regulate the implementations of access to information, whereas Ethiopian National Archives and Library are responsible to collect, systematically organize, preserve, and make the information resources, whereas the Ethiopian Communication Agency also a regulator of the telecommunication sector. So we have no a single regulatory authorities now. So as I mentioned earlier, there are different or various organizations who are responsible about a personal data now. The main challenges both at the regional and international level is there are the fragmented approaches to data protections and privacy laws nationally, regionally, and internationally poses many challenges to going forward. And Africa does not have a comprehensive data protections laws that govern collection, storage, processing, and disseminations of personal data. So since privacy is an evolving concept, there is a weak privacy enforcement laws in Africa. And personal information could easily be shared with taxation authorities and for different armed or police officers for the purpose of security. So you can obtain the personal data easily, from different organizations in Africa as well as in our countries, because of we have no data protections laws. The solutions or my recommendations is an international harmonized data protections law in the form of conventions or treaty is currently is important, and attention should be given on developing a model law on the subject matters that govern all countries. And it is important to develop appropriate policies to facilitate the implementations of laws and guide the workers of its organ. And it is important to establish an independent organ mandated to oversee and enforce data protections and privacy in the countries, and requires all government agencies to appoint data protection officers or data protection compliance officers within their offices. Thank you. I ask you a great apologies for internet interruptions, and I have taken some minutes. Thank you so much.
Thank you very much, Honorable Haile, for that presentation. Honorable Diakuga, are you available to provide a wrap-up? Would you be able to unmute yourself, Honorable Ombudsman? No, it seems like the Honorable Ombudsman still has a problem unmuting himself. We just want to say thank you to everybody. What we've done, because we've exceeded our time, we're going to do away with the question and answer session. What we will do is actually send the questions through to the presenters and ask them to please provide the responses to the different questions that we've been asked. We've had quite a few questions. We apologize for the quality of the interpretation, and we hope the connectivity will be a bit better the next time. Honorable Kaleka is not available as well to do the thank you. We'd just like to say thank you to everybody that has attended, and hopefully you will join us for our next presentation, which is approximately 6 weeks' time in August sometime. Thank you very much. See you next time. Thank you to our presenters as well for availing yourselves.
And thank you. That is the end. Thank you.
Thank you.